Thank you very much for coming to the CBI talk. Before I begin, I want to confess that this is not a this is a new idea that I'm going to talk about today. It's not one that's been fully written up and vetted, and the implication of that is I'm going to get a lot from your feedback. So if you have any questions, if you have any concerns, please do voice them. With that caveat, let me begin. So the title of the talk is up on the screen, but it's kind of a thick title, and so I think the background will help clarify what we're going to try to do in this talk. We here being Richard Holden, who's going to come and teach a class here in January, a short course, and myself. And it's also part of a longer agenda that I'll comment on in the last slide. So let me start with somebody whose name you should be familiar with. At least we require your familiarity with his name before you graduate, which is Ronald Coase. In 1937, he asked a really profound question. And the question was, if markets are so efficient, remember we're at Chicago, so we believe this. If markets are so efficient, why is it that so many transactions in our economy take place within firms rather than on markets? Okay? And this sort of question arises over and over again. So today, if you look at statistics on where transactions take place, and by transactions I mean things like, Boeing has to buy rivets for its planes. It could produce those rivets itself, or it could buy it on the market. You would think that if markets are efficient, it would just buy it from some supplier on the market. Instead, it produces itself, for example. That's what I mean by a transaction and how it can take place outside or inside of firms. And if you look at statistics, we find that about 50% of US transactions take place within firms rather than on the market. We also find, surprisingly, that you find such high numbers even in international trade. You would think that when you take a product from China and import it in the United States, or from Brazil and import it in the United States, there's a Chinese firm or a Brazilian firm that's selling to a United States firm. Now, as it turns out, that's not always the case. You often find that the transaction is taking place within the same firm with branches in these countries. So it's a multinational that produces in Brazil and imports the widget into the United States, into its own facility here in the United States. And about 1/3 of all international trade is intra-firm, within firm, not on the market. Coase's answer to why it is that so many transactions take place in firms rather than on the market was transaction costs. And for this insight, he won this and one other big insight that you might know of, he won the Nobel Prize in 1991. But this was a big component of this, understanding the scope of firms by appealing to the idea of transaction costs. Now, transaction costs we have to unpack. I mean, everybody knows what everybody has heard the term transaction costs, but you have to define what you mean by transaction costs. And in general, there are two types of transaction costs that we can think of. We can think of ex post transaction costs and ex ante transaction costs. Ronald Coase was thinking mainly of ex post transaction costs. That is to say, Augustine and I have decided that we're going to transact over a widget. What is the ex post transaction cost? We have to agree on exactly what the features of the widget are. We have to negotiate over the price. We have to reduce that to a contract that can be enforceable in court. It's those ex post haggling costs and just kind of writing down costs that are what Coase was talking about. And if those are really, really high, you do things, transactions within firms. And if they're really low, you do them on the market. Now, people have elaborated on other types of ex post haggling costs. You can have asymmetric information be a source of haggling costs, for example. Bounded rationality or cognitive problems can also be an ex post haggling cost. Those are all packed in together as something that happens ex post after I find Augustine and we know what we're going to transact on. Oliver Williamson in 1975, then again in 1985, said that there is another type of transaction cost that one should consider, and that is the idea that there may be ex ante investments that one or both parties to a transaction want to make, And the problem is that there is contract negotiation or renegotiation after those investments take place. And by the way, those investments are relationship-specific investments. They're reliance. And that because of that, because contracting takes place after that, or there's renegotiation contracting after that, there can be the potential for holdup. And that potential for holdup discourages ex-ante investment from taking place, because if you make the investment, and I'll explain this with a numerical example, if you make the investment and there's ex-post contracting, that ex-post contracting doesn't get you back all the returns on that investment, and so you don't make that investment in the first place. I'll explain that a little bit more in just a few minutes. Before this idea, and generally for elaborating on the idea of transaction cost, Oliver Williamson wins the Nobel Prize sometime later in 2009. Okay? So these are big, important ideas in economics, and I'll show you some of the implications for law. So let me provide a more nuanced, or it's just an example, but with more concrete numbers to illustrate the problem of holdup. Okay? So imagine that you've got an upstream seller and a downstream buyer, and this could be something like Augustine's the upstream seller. He's going to sell me a widget. I'm the downstream buyer. I'm going to buy the widget. I'm either going to use that widget or I'm going to turn around and resell it. Okay? That's the context that we want to think about. And let's suppose that the upstream seller has a marginal cost of 16 to start out with. But if the upstream seller makes an investment, a relationship-specific investment of 5, he can lower, or she can lower her marginal cost down to 10. Okay? And it should be obvious that investment is efficient. So let's suppose that we're just talking about purchasing 1 unit of the good. What do you get when you invest? You get a savings of 6. Your marginal cost from 16 to 10. And the cost to doing that was just 5. And 6 is more than 5. Think about the downstream buyer. The downstream buyer, let's suppose it values a unit at most at 32, and maybe that's because they themselves valued at 32. The downstream person values it at 32, him or herself, or they plan to resell it to some consumer for a subsequent price of 32, whatever you want. But now, again, let's suppose that the buyer too can make a relationship-specific investment. And the relationship-specific investment is, again, 5, just for simplicity. And that can raise the valuation of the good to 40. Okay? And if, this is, I'm using technical terms like investment and relationship-specific investment, but you can imagine, let's be a little bit, I'll give you a concrete example. And I'll give you a number of these throughout the course of the talk, but again, let's go back to Augustine. Augustine's upstream, I'm downstream. Augustine makes parts for a piano, okay? And I want the piano tuned in a particular way, and he has to change the way he produces piano to make sure it's tuned exactly the way I like it. That's the relationship-specific investment. If he does that, for him, let's suppose that making an investment into making that into being able to produce that actually lowers his costs in some way, if he changes the production process to produce a specific type of piano. And I, in turn, can take that specific type of piano and invest in, say, marketing or some sort of branding or something that makes it so that end consumers want to buy this specific piano that's tuned in this particular way. Okay? Something like that. But again, investment is efficient from upstream and downstream. For downstream guy, if you raise the valuation from 32 to 40, you get a gain of 8 for the relationship, but it only costs you 5 to invest, so you get a net gain of 3. Okay? Now, I'm going to make 2 assumptions that are going to generate problems. Let's suppose that parties can renegotiate after an investment is made. Okay? Parties can renegotiate their transaction after an investment is made, and that parties, this is fairly innocuous, I just wanted to fix terms. Let's suppose the parties, Augustine and I, have equal bargaining power. Okay? That's going to lead to a lot of problems. Let me give you one of these examples. Let's suppose that that Augustine, is the seller, is thinking about making the investment, knows that it's going to cost him 5, and the relationship is going to benefit to the tune of 6, but because we have equal bargaining power, we split that surplus 50-50, so he's only going to get 3 out of that 6. So he has to invest 5 but is only going to get 3. He's not going to want to invest. I'm going to face the exact same problem as the downstream guy. I could invest 5. The relationship would benefit to a tune of 8, but the problem is we have equal bargaining power. We're going to split that 8 in 2, and I'm going to just see a gain of 4 on my investment of 5, so I'm not going to want to invest. And this is the familiar holdup problem. This is the holdup problem that Williamson was talking about. Okay? We make an investment, but because we don't extract all the surplus from our investment, we don't make the investment. Okay? Or we don't want to make the investment. Okay. Now there's many ways to solve this problem. Many ways to solve this problem. One is vertical integration, and this is what connects Williamson and Coase. So let's suppose that Augustine and I merged into one firm. That one firm would be able to make all sorts of decisions, including should we invest in reducing marginal cost? Should we invest in increasing consumer valuations? And if it did that, what we'd get is a really big surplus. The joint firm would be able to sell the good for 40, higher valuation. It would pay a lower marginal cost of 10, and then it would have to pay for investment. The first $5 investment cost is due to investment reducing marginal cost. The second one is due to increasing the consumer's valuation, and the net surplus is 20. And before we decide to merge firms, we might just figure out what the price is that we're going to sell at, or how we're going to split the surplus, and we'd split the surplus 50-50 because we have equal bargaining power. We'd each get 10. But the key idea was we had to merge firms. We had to merge firms. We had to vertically integrate. Okay? And that's, again, the basic story is, number one, holdup is a problem. It discourages ex-ante investment. We can think of that broadly as a type of transaction cost that encourages us to do things within the firm rather than outside the firm. How do we know that it works within? It's not a problem within the firm. Look, vertical integration gets you the answer. Basically, we're appealing for managerial authority instead of market transactions. There's another simple solution. I bet you the first thing you guys are thinking about is, why don't we just contract on investment? Augustine and I will write a contract that says Augustine is going to, if Augustine makes an investment in reducing his marginal cost, and I make an investment in increasing consumer valuations, then we specify the price at which we transact. Otherwise, we don't transact. Something like that. Okay? We could write what's called a contingent contract, contingent on the investment. Now, the problem with that is that it's not easy to contract on these sorts of investments. A lot of time, I mean, there's the standard ex post haggling problems. You know, we have to agree on exactly what the prices are, or there might be bounded rationality, things like that. But a more subtle and, I think, more important reason is that sometimes investments are observable to each of the parties. I can see if Augustine has invested in reducing marginal costs, he can see whether or not I've invested in increasing consumer valuations, but we can't really get a court to see that and verify it, and so we can't write a contract on it. Let me give you an example where this might be the case, and I think an important one that a lot of us are probably familiar with. So think about Apple and AT&T. So Apple and AT&T, before the iPhone comes out, sit down and say, okay, what we'd like is we'd like to transact. Apple will produce a smartphone. AT&T will produce a network where people can use, on which people can use the smartphone. We'd like Apple to produce a really good smartphone, okay? So there's a lot of joint surplus. And we'd like AT&T to produce a network that can really handle the data requirements of this new smartphone. But it's very hard to specify in a contract what is a good smartphone. And it's very hard in the contract to specify exactly how big the network must be. Okay? As a result, you can imagine that we can't write an explicit contract that says that. Okay? And again, in order to really envision this, you have to think of yourself before an iPhone's around. How would you write a contract to specify the iPhone? And indeed, how would you write the contract? Think about this. How you'd write the contract for the network before you knew what the demands on the network were going to be, or what consumers really want from the network. So I'm going to assume that this is the problem. And there's a whole branch of this literature that says, of the literature on the theory of the firm, that says, okay, we agree that there's a big problem with incomplete contracts. Okay? So we really want to be able to solve this problem of hold-up and ex-ante investment in the context where we can't write contracts on investment. Okay? So I'm going to assume that that's the case in my hypothetical. You can't write a contract on investment. Okay? Or another way to say this simply is that there are incomplete contracts, or there's a reason for incomplete contracts. Okay. The first answer, there's still a way to solve this problem, and the solution was proposed in a pair of papers, one by Sandy Grossman and Oliver Hart in 1986, and then the second one by Oliver Hart and John Moore in 1990, and they say, look, parties can use asset ownership, and I'll explain what that means in a second, asset ownership to solve the problem. They can divide up ownership of certain assets in order to solve the problem. And now let's go back to our numerical example. If you remember it, I'm not going to put the numbers up just now, just going to illustrate this conceptually. Let's suppose that the seller, Augustine, owns a key asset that the buyer needs to operate. Okay? That could be the whole firm of the buyer, the downstream firm, or it could be just a key asset the downstream firm buyer needs in order to function. If that happens, then the seller can use the threat of shutting down the buyer. Okay, the upstream firm can use the threat of shutting down the downstream firm to extract all the surplus from trade. Okay, all the surplus from trade. And that means that, for example, if the upstream firm decides to invest 5, generating a surplus of 6, then it can use ownership of the downstream firm's key asset in order to make sure that it gets back all that surplus, the 6. The reduction of cost worth 6 from the downstream firm, and thus investment is efficient. And conversely, if the buyer does the exact same thing, so if the downstream firm owns a key asset of the upstream firm, the downstream firm knows, hey, if it invests 5, increasing the value of the transaction by 8, it'll be able to extract that whole 8. And thus it should go ahead and invest. Okay? So it works symmetrically, but the problem is, who should own the key asset? Okay, who should own the key asset? And the answer that Grossman and Hart give is, because only one of them can, is it should be the entity that has to make the more valuable investment. In my numerical example, which was arbitrary, I'll admit it, you can flip it around. In that example, the return to the upstream firm's investment was 6. The return to gross, before netting out investment costs, the gross return to the downstream firm was 8. Downstream firm had to make the more important investment, so in my numerical example, Grossman Hart would say the downstream firm should own a key asset of the upstream firm. The buyer should own a key asset of the seller. Okay? And so look, you can get, with asset ownership, at least one of the parties invests, and not only that, one of the things that make this a brilliant theory is that it extends what Ronald Coase and then Oliver Williamson were saying. They were just talking about whether or not a transaction takes place within firm, on the market, or within firms. Grossman, Hart, Moore explain who should own firms, or who should own assets. The people that should own are the people that have to make a more important investment, right? To whom you really want to assign residual claims over the surplus, okay? And for this, Oliver Hart is, for the last few years, perpetually been on the short list to win the Nobel Prize. It's a good bet that sometime in the next 10 years he's going to get the Nobel Prize for this idea. Now, as soon as Oliver Hart said this, and his co-authors, economists started coming up with alternatives to asset ownership that can solve the problem. And the one that I want to focus on in this talk is one by Philippe Aguillon, Matthias Duattrepont, and Patrick Ray. And in 1984, they suggested that there is a way to write a contract that allocates bargaining power between the two parties that solves the holdup problem. Not only does it solve the holdup problem for one party, just like asset ownership, it'll actually solve the holdup problem for both parties, causing both parties to invest. Okay? It's a very creative solution. comes out of the mechanism design literature, some of you may have heard of. Their contract has two important components. One, it's got to give a default option to the seller, the one that's making the less important investment. That default option will guarantee the seller enough surplus to encourage the seller to make some investment, and then it gives the other party, the one that's making the more important investment, the ability to make what's called a take it or leave it offer, the point of which is to allow that other party to extract the remaining surplus from the firm. Okay? Guarantee the seller just enough return to make the investment, and then give the buyer the remaining surplus so the buyer also makes the investment. Okay, and to illustrate this, let me try to apply it to our numerical example. Okay? Remember there are two components of the contract? Here are the two components of the contract. I apologize. These downward arrows were PowerPoint's way of substituting. This is Q sub 0, subscript 0. It instead turned it out like this. So I apologize for that. So whenever you see a downward arrow and 0, just think about it as a subscript 0 or not. So you specify default option, P sub 0, Q sub 0, that the seller can force the buyer to take. That is to say, in exchange, that Augustine can force upon me, the buyer. Okay? No matter what. And then we allow the buyer to make a take it or leave it offer to the seller. So I can propose an alternative trade to Augustine, which he can choose or reject. If he accepts it, then we proceed on. If he rejects it, he gets his default option, the P naught, Q naught that's up there. Okay? And that's the whole contract. That's the whole contract. And so, and I'm going to show you how this gets both sides to invest. So the key to setting that default option when we're negotiating the contract is to make sure that the seller has an incentive to make the investment. So the seller's got to be willing to make the investment. And it's got to make sure that seller, because we have equal bargaining power, you split the surplus evenly from the situation when both sides invest. So this is again really bizarre to read. I apologize. This is, you're going to set the price of the good. Let's put P naught is going to be the price of the good that the seller is going to sell to the buyer at. The marginal cost is going to be 10. That's multiplied by the quantity, and then you got to pay an investment of 5. That's what you get. That's what the seller gets if the seller invests under the default option. If the seller does not invest under the default option, it's going to get the price of exchange minus the marginal cost, which is higher, 16 times however many units they're going to sell. Okay? As it turns out, so long as quantity is 5/6 or higher, the seller is going to prefer to invest. And so all we have to do is set the default option such that the quantity exchange is 5/6. Now that's going to seem strange. How do you exchange 5/6 of a unit? Don't worry about that. We could have been talking about thousands of units, right? Where 1 Q is really 1,000 units. And so now we're really talking about 5/6 times 1,000, which is a number that might be more easy to grasp. But we got to set that quantity, and then we just have to set a price, given that the seller's going to invest, that the seller is going to for sure get a surplus of 10. And that price is going to be 23 1/3. Okay, and you can verify that. It's just price minus lower marginal cost times the number of units that are sold, 5/6, minus the investment has to equal 10. Just solve out for P naught, you will get a price of 23 1/3. So what's the default option? It's that Augustine is going to sell me 5/6 of a widget for a price of 23 1/3. That's his default option. And as long as he has that default option, he will always be able to get a surplus of 10 and be willing to invest. What'll I do? Well, I, as the downstream firm, have the ability to make a take it or leave it offer. I can make a take it or leave it offer in a situation where I don't invest, or a situation where I do invest, and it's very easy to verify that, in fact, I will be able to make more money if I invest. Okay? And the offer that I'll make will extract all the joint surplus minus the amount that I have to give him given his outside option. That joint surplus, remember from the last slide, is 20. But I got to pay Augustine 10 because he has the ability to go to the default option. So I just offer him a price that gets him 10. And that price is going to be 25. I'm going to offer a price of 25 and offer to buy 1 unit of the good. And we're going to end up with 10 for him because he has the spread of an outside option, the default option, and I'm going to get 10 because I used my take it or leave it offer to extract the rest of the surplus. That's really a cool insight, actually, because we thought that we could get both sides to invest. You get one or the other, and then all of a sudden, in 1994, we discover you can write a neat contract that gets both parties to invest. So everybody agreed this was neat. Everybody agreed this was neat. But over time, we started thinking, meaning the economics community started thinking, we don't really see this contract in the real world, or I don't see it. I mean, so I don't often see a default option, and how do you assign take it or leave it powers to the other side? And so people neglected this. You had some people sometimes write about it, but in general, this was neglected. Our contribution, Holden, my contribution, is we think that ADR contracts actually exist. So Aguillon to Battefonte-Ray contracts, you can call them bargaining power contracts, they actually exist. Okay? And we're going to give you a few examples of these, and then we're going to talk about some of the implications of that, including some legal implications. So here, let me give you one example. Let's take a take or pay contract. A take or pay contract is a contract that says, usually it's for the seller. The seller is able to say to the buyer, you have to agree to take a fixed quantity of output at a fixed price. And if you don't, it doesn't matter if you take it, you still have to pay that fixed price. Okay? This is very common in the natural gas industry and sometimes other parts of the energy industry. And so in this context, how would that work? First, the seller, Augustine, would have a take or pay provision that would require me, the buyer, to pay him $23 and $3 for 5/6 units. And I could decide not to take it, the actual 5/6 units, but I would still have to pay $23 and $3 to him. Okay? Now, obviously, in that sort of situation, I'll just want to I'd rather take the natural gas than not. So in effect, it says I have to take this amount. Okay? So I will, but that's just the default option. Now we can renegotiate, and I'll want to renegotiate with him and say, let's try some other numbers, but he'll always be able to force me to at least take 5/6 units for $23 and $3, which is exactly the default option that ADR suggested we have in my example. Okay? And now, how is it that we make sure that I, the buyer, despite having to be subject to this take or pay provision, how do I get bargaining power, the residual bargaining power? In these contracts, it's not done through contractual mechanisms. It's actually done through a hybrid. The seller got it through a contract. What I get bargaining power through is through ownership of assets. And so in the energy industry, what will often happen is that the buyer, although subject to a take or pay contract, will actually own a key asset that the seller needs to deliver his good. So very common is the buyer will own the pipeline that is the way that the seller is going to move his or her natural gas to consumers. Okay? And I can use the thread of that pipeline to extract whatever surplus is remaining in the transaction, and that surplus is higher when I invest than when I don't invest. So I invest too. Okay? So that's the easiest example, take or pay contracts. Another contract that might achieve this is what's called an output contract, which you might have heard of in contracts class. So I could imagine a situation where, and here what's important is, remember, we just want a sale of just one unit. So I'm going to assert that you can write and you can, an output contract either with, that gives me certain flexibility but maximum transaction of one, that works like this. If you remember, an output contract is a situation where a seller can force the buyer to take whatever output the seller produces. It could be a small amount, it could be a large amount, doesn't matter. Okay? And you can put a cap on it. Okay? That's explicitly done in many contracts. That's what an output contract is. How would it work in this context? Let's suppose that the seller, Augustine, decides that he's in our contract, we're going to have an output contract provision that allows him to put onto me any quantity of output he wants to produce up until 1 for a price of 25 per unit. Okay? 25 per unit. We can verify that seller, Augustine, would choose to invest. If he invests, he gets 25, which is the contract price. The marginal cost is 10. Q is the number of units. You subtract by 5, subtract 5 from the investment, that's greater than 25 minus 16 at Q, even if you don't have to pay 5. Okay? And that's going to be true actually for any Q greater than 5, 6. So he'll be able to, as long as he chooses 5, 6 or higher, he'll be able to guarantee himself a return, a positive return, net return on his investment in reducing marginal cost. Okay? In fact, he would want to go all the way up to quantity of 1, the maximum, because his total profits rise in quantity of sale because he's always getting a higher price than his marginal cost. Just in my numerical example. Okay? That's where the cap comes in. And I'm able to extract rent by one of two sources. One is you could do the same sort of thing, some sort of asset ownership that allows me to affect his business in such a way that although I've got to give him 10, beyond that I can punish him and extract all the surplus. That gives me an incentive to invest. Alternatively, we can do it through some sort of exclusive dealing. Although I have to take the seller, I have to take Augustine's output, okay? Right, he'd be able to place all that output to me, however much he produces. This exclusive dealing contract will prohibit him from selling output also to anybody else. So he can only sell to me. And I can use the threat of enforcing that exclusive dealing contract in order to make sure that he gives me whatever surplus is left over, in particular whatever surplus could be achieved because I invest. Okay? And by the way, a requirements contract is just a flip of an outputs contract. A requirements contract says instead of Augustine being able to put to me any output he wants, I, as the buyer, can demand from him any amount of output I need, and he has to produce it. He has to supply me. Okay? And then the exclusive contract works the other way. The thing that binds me is the fact that I can't buy from anybody else. Given that I can take whatever I want from him, I have to agree not to buy from anybody else. So these are some examples of situations where you can write a contract that allocates bargaining power, sometimes in combination with some asset ownership, and achieve the first best. Now, sometimes legal issues arise. Very early on, there were concerns in the law about whether or not there was mutuality in these contracts. That is to say, did each party give something to the other? And case law quickly overcame this, and so did the UCC Section 2306. And they said mutuality is not a problem, even if there's these extreme contracts and the quantity term is uncertain. Now, a second issue that came up was courts would sometimes say, okay, we want to make sure that the trade is balanced. If Augustine gets to put any amount of output onto Anup, then Anup should be able to have something over Augustine. And so what they'll say is, okay, make sure that Augustine can't sell to anybody else. There's some exclusive dealing clause in there. Now, that's okay under my theory. And the reason or under the ADR mechanism, the reason it's okay is because that's part of allocating the residual bargaining power after the seller, Augustine, has his outside default option. The exclusive dealing guarantees me all remaining bargaining power so that I have an incentive to invest. So that's not a problem. A last issue that often arises is good faith. So if you look at 2306's comment 1, it says that you have to your demands. So when Augustine has this outputs contract and he wants to put some quantity to me, wants me to be able to force me to buy some of this quantity, that quantity has to be determined in good faith. Okay? He can neither force too much or too little on me. Okay? And typically that's determined by what did he do last year if we're repeat dealing, or what seems reasonable given what he's produced, something like that. And the basic idea is to remove what's called excessive elasticity. We want to have some flexibility with an output contract, but we want to eliminate too much elasticity or flexibility. We want to make sure he doesn't get too much of it so that he can abuse that power. Okay? Now, courts have to interpret this. And if courts understand that the purpose of this contract is to induce reliance by the seller, say an outputs contract, induce reliance by the seller, reliance investments, then it's okay, because then they'll understand that it's sometimes okay for Augustine to make extreme demands, because those extreme demands, without them, he wouldn't have made the investment in reducing marginal cost. Okay? So courts have to understand, as long as they do, that's okay. Now, sometimes there's a problem that arises, and the reason is because if you look at the legal literature on outputs contracts and requirements contracts, even on take-or-pay contracts, they don't quite get the reliance point. That literature mainly assumes that the reason we have these contracts is to assign certain risks to one party or the other. One party or the other. So the reason why Augustine has an outputs contract is because there's some risk that Augustine wants to put to me. Okay? There's some risk that Augustine wants to put to me, and the outputs contract gives him that ability to put that risk to me. Not just the quantity output, but some risk associated with that quantity output. Flip side, if there's a requirements contract, I want to be able to put the risk of further downstream consumer demand onto him, so it could be high or low. I want to be able to demand whatever I need from him, whether it's high or low. That's what they think. And so they're always tying things to, can you show that there was some risk downstream that caused you to require too little or require too much? Or were there some problems at the plant that required him to produce too little or too much? That's not the key reason why, that's not the only reason why you'd have these contracts. We're providing another reason why you'd have these contracts, and that is just to get the reliance. And so as long as courts see that, and parties can come up and say, hey, I had to make an investment, and that's why I required an outputs contract, or that's what the seller would do, or a buyer says, I had to make some sort of effort to increase valuation, and so that's why I need a requirements contract. As long as that's going on, and courts understand then that that's why the contract provision is put in, and good faith shouldn't try to interfere with that, we'll be okay. Until they do that, you could have problems. So a good article is one by Victor Goldberg in 2007, where he talks about a case that you probably read in contracts, which is Feld versus Henry S. Levy, where you had a baker that was producing breadcrumbs, seller producing breadcrumbs for a buyer, and the contract had it was an outputs contract. Basically, the seller could place as much or as little as he wanted to the buyer, and the seller decided they're not going to put any because the transaction was uneconomical, and the court said, hey, you can't do that. You can't do that. It's not good faith to shut down completely, even if it's just uneconomical. And Victor Goldberg criticizes the court in that case and says, no, you didn't understand. You needed to allow the seller to have this right because they too were making an investment. They were making an investment in buying a new type of oven to produce these breadcrumbs. And the court didn't consider that, and as a result, it didn't enforce that right that the seller had. Going forward, then the seller feels uncomfortable making that sort of investment, given the court's not going to protect that investment with this outputs contract. Okay? In short, the normative punchline of what we're saying is courts should allow extreme elasticity. The person that has the outputs contract to put a lot of output or put very little output. The person that has a requirements contract to require very little output or require a lot of output. When the point is to get investment by that guy and the other side has another source of bargaining power. That's the punchline. Okay, so it provides a new normative framework, or our goal is in part to provide some normative framework for courts to understand the interplay between those types of contracts and this broader theory. So with that, I kind of want to stop, but I want to talk a little bit, I want to summarize, and I want to talk a little bit about the future directions of this research. So what have we learned? We've learned that there are mechanisms other than asset ownership, or that complement asset ownership, that can solve the holdup problem. In fact, can do better than asset ownership to solve the holdup problem. You can get both parties to invest. We've given you some examples of them. In fact, there are some others that we're also exploring. MAC clauses in merger agreements, easy default triggers and credit agreements. These are all things that often that can be done to allocate contractually bargaining power between the two parties so as to basically mimic these ADR mechanisms. Okay? But the really neat thing is that you can do it sometimes with a little bit of both, and you can get both sides to invest. Okay? Future research, we're going to try something else. Economists, in response to Oliver Hart, they didn't just say, oh, there are these contractual mechanisms that can solve the problem, specifically the ADR mechanism. They suggested alternative mechanisms. So there's a somewhat complicated type of mechanism or procedure that's suggested in a pair of articles, Moore and Rapullo in 1988 and Mask and Tirole in 1999. And they say that these sorts of mechanisms can convert observable non-verifiable investments into investments that are verifiable. Okay? I'll admit it's a complicated mechanism. And because it's so complicated, the response people have had is, again, it's too complicated to observe in the wild. It doesn't exist. I mean, this is nice academic material, but it's not really practical. And we think, Richard Holt and I think, that in fact those types of mechanisms also exist in the real world. They don't exist in contract, which is where everybody's been looking for them. In fact, what they exist in is in legal procedure. It's really remarkable how legal procedure, we think, mimics this complicated mechanism. The idea that you have plaintiffs and then defendants and then settlement offers looks a lot like what these guys were talking about. And so we're going to try to argue that that's yet another mechanism. And so in effect, what we hope to do at the end of this process to be able to say asset ownership is not the only solution. You can write contracts over bargaining power, just like ADR suggested. We see them in the real world. Not only that, you can have these complicated games or mechanisms that cause things that are unverifiable to become verifiable. You don't see them in contracts, but you see them in litigation. And voila, we have all these great alternatives to asset ownership to solve the holdup problem. Okay? And that means that we can have more transactions outside of firms in the marketplace. And we hope, in the long run, that that'll be able to maybe explain two big issues that have arisen in the empirical literature on the theory of the firm. One is, while the 19th century and a good portion of the 20th century was the era of vertical integration, bigger and bigger production units, companies producing stuff. Think of Henry Ford, or GM, things like that. Recently, we've been seeing a vertical disintegration of firms, which is to say firms have been breaking apart, vertically disintegrating. Instead of having a merged upstream and downstream firm, now you're going to have separate upstream and downstream firms. And the clearest example of this is all the hubbub about outsourcing. Outsourcing is another form of vertical disintegration. Apple, instead of producing the iPhone, both the components and the final product in California, says, okay, we're going to produce all the components, the screen, the chips, in Asia somewhere from different firms, say Samsung, okay? And then we're going to assemble it in California and then sell it to consumers. That outsourcing is an example of vertical disintegration. One reason for this might be that we have found an alternative, a contractual alternative to integration to solve the holdup problem. Okay? That's one possibility. There are other theories out there for why this is occurring, but we're going to suggest that maybe the fact that these other mechanisms that economists have come up with actually exist in the wild, that's the reason for the disintegration. The other thing that we're hoping that this might help us explain is you see a lot of variation across countries. This comes out of the law and finance and law and development literature. A lot of variation across countries in how big firms are, how much they rely on vertical integration within the country to solve holdup problems, or to basically how big firms are. That's the big issue. And that sometimes that relates to the nature of their legal systems, how big firms are. And we want to offer a particular mechanism for why that's the case. Why in some countries legal mechanisms lead you to have vertically integrated firms, in other countries it leads you not to have vertically integrated firms, to have more transactions on the market. And we suggest what might be the case is that in countries where you can write these and enforce these complicated contracts, the output contracts, requirements contracts, take or pay contracts, you can rely on those contracts to do the work of vertical integration. In places where you can't do that, you have to rely on the vertical integration. So depending on how good your contract law enforcement is, you may be able to explain cross-country variation in the size of firms. Okay? Now I want to add one last twist as perhaps fodder for the Q&A, and that is, there is one other interesting feature of this. In everything that we've been doing, we've been trying to say, look, there are ways other than vertical integration that you can solve the holdup problem. Some of it's by contract, some of it's going to be by legal procedure. Okay? That's been the goal here. But there are ways sometimes in which courts get in the way, or the law gets in the way. And this, we think, is a problem for us to address down the road, but I want to put it up front for you. There are some times when courts take a transaction that was on the market and recategorize it as something within the firm, or vice versa. And the easiest example for you to see is the following. Look at how courts deal with the boundary between employees and independent contractors. Let's suppose that I decide that I'm going to hire somebody, okay, and I want that person to be functioning not as an employee but as an independent contractor, maybe to offload some liability, maybe for some other purposes, Okay, I want to do it on the market through an independent contractor. Sometimes courts will just look at that relationship and then just switch and say, no, 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 that person is categorized as an employee, not an independent contractor for some legal purpose. And so in effect, it puts that worker and that labor transaction from outside the firm, moves it inside the firm by law. Now that eliminates my flexibility about deciding where to put that transaction, on the market or within the firm. And that can lead to really interesting implications about how firms are structured. Okay? That's important to put back into this literature. And you'll see this not just in labor, but you'll see it in bankruptcy and other places. But that's, again, a talk for a later day. I'm happy to do a Q&A on this. With that, let me stop. Silence could either be disbelief or complete acceptance and surrender. I'm going to go with the latter interpretation. Okay.
Okay, it seems that courts have a very important role to play here. What about taxation? I mean, because the decision whether to outsource, to disintegrate, or to go vertically integrated might be crossed by taxation somehow?
I agree. So you definitely see this in the outsourcing literature. If you tax market transactions more than you tax intra-firm transaction, firm-level transactions, you're going to encourage more firm-level transactions rather than market transactions. That's going to make firms larger. And vice versa, if you tax firm transactions a little bit more, although usually it's the other way around. The flip side is that sometimes firms can get around it through transfer pricing. Of course, that's typically done through the same firm in two different countries, but then, so it's really still intra-firm, but just avoiding taxation within the firm. Sometimes you can get around it, but it's not a complete solution. But for sure, taxation is going to play a role in addition to what courts do. I'm sure Omri has a question.
To monopolize we can talk about this for hours, very interesting. And just a thought, another example for your purpose is for a contractual arrangement that falls, that maybe places the transaction on the market, but it's kind of a hybrid within the firm or outside the firm. Firms' buyers, large buyers, sometimes contract with their suppliers to own the machines that the suppliers use to produce those things that the suppliers need to do in order to the relationship-specific investment is to build a production line that produces, let's say, for Ford, these things that only Ford can use. Well, Ford will pay for that, and they will own it. And that means that the buyer has a lot of bargaining power. The seller cannot turn around and use these machines to sell to Chrysler.
That's right.
It's a transaction on the market. They are separate entities, but to co-ownership, I don't know. You may want to call it an intra-firm arrangement.
Yeah, I like that too. So I mean that's another great example. And in each of the so that solves part of the problem because it solves Ford's problem of making sure that you don't go to the supplier doesn't go to Chrysler. And then we just have to think about what rights the other side has to make sure they at least get some outside option or the remaining.
Why do they need to get anything? If their investment is paid for, it is done. It is sold. Trivially.
So you're saying the upstream firm is actually going to do the downstream firm's investment, reducing marginal. The downstream firm is going to do the upstream firm's investment and reducing marginal cost.
That it's observable. They know what the right investment is, and we want to get the supplier, the upstream supplier, to invest properly. Let's just agree what it is, and the downstream buyer, will reimburse you for the cost, per receipts.
Yeah, so now one of the issues there is that's a neat way of converting something that's observable into something that's verifiable and not necessarily something that's, because I can verify that I bought the asset. A lot of times in these transactions, so this is going to solve a lot of problems, but sometimes in these transactions, one of the parties doesn't know what the investment is that the other party should make, and so can't offer to actually make that investment, right? And so that comes up as a problem. And so ADR want to solve that situation too. They all typically assume that the buyer doesn't know what the seller's investment should be, the seller doesn't know what the buyer's investment should be. They just want the party each to make investments that increase the joint surplus, and they get our residual claimants in each of their own investments. And sometimes that's a little bit, that gets to be a little bit complicated. But this is a solution in this situation where you know what the investment is the other party should make. Now the other thing is that sometimes you can solve the party. I mean, I could imagine extrapolating and say, let's suppose that the supplier can just decide what it is that the buyer is going to own, right? They decide the investment, but whatever it is, the the seller is going to pay for it. That might be a way to solve it, but you still need to cabin to make sure that the downstream firm isn't using it as a way to get the upstream firm just to, or sorry, the upstream firm isn't using it to get the downstream firm to just buy lots of useless stuff as well. So there's got to be some kind of cap on it. But I think it's a fruitful idea. Bram.
Yeah, I think the availability of financing actually will also induce the firm decision to make investment. I mean, like in power purchase agreement, sometimes like electricity company in my country, they will decide whether they will build their own power plant, or if they choose a power purchase agreement system, usually they use a take or pay system.
Yeah.
Then they will fix the payment for like 30 years, so the contract price is already settled for 30 years. So they cannot change unless there's like material changes, but they will buy whatever is produced by the company. But then it again decide whether it is cheaper or not, or whether the company has the money to build their own power plant. If they have the money, usually they make by themselves.
Yeah.
But if they don't have any money, then they will choose that, okay, we will let you invest, we will make sure that you can sell it to us, but we need to make the price fixed so we can count. But each cannot have like calculate the cost for a long time.
Yeah, so I'll make 3 points about this. First is about the long-term nature of those power contracts. The reason for that is because the investments by one side are so big that you need a long period of time to kind of amortize that. A footnote to that is another argument that people make for why it's so long-term is just because they want to ensure the producer or the investor in the plant against price fluctuations down the road. But so that's point number one. The second point is that you can break down the financing into two purposes. One of those purposes is going to be just depending on what the price of capital is provided by the buyer. It could be just another way to set the default price. It's just another way to transfer some money up front for quantity. So that's part of the component. The other component of this is actually just, I think, a variation of Omri's mechanism, which is you're getting the buyer to own a part of the investment through or exposed to it due to the financing, right? So if there's failure, the buyer feels a part of it as well. And so that might induce the buyer, or through this, the buyer might make it so that the seller is willing to make the investment in the first place because the seller is able to offload some of the risks of the investment to the buyer. I want to say one thing combining these two things. Whenever I talk about it, and whenever the literature talks about it, they tend to think of two extremes, 0-1 solutions. Either you're doing everything on the market, 0, or 1, you're thoroughly vertically integrating. And I think what Omri's comment points out, and Pram's comment reinforces this idea that you can have these hybrid arrangements, including the stuff that I was talking about, where you're somewhere in the middle. You're halfway between vertical integration and contracting. And I just want to show that you can locate it in multiple different places and solve holdup. The one neat thing that doesn't come out of that, but that does come out of the presentation, is that as you get closer to contracting, there might be, and just away from pure vertical integration, there might still be ways to get first best, to get both sides to do the investment, which has been a challenge in this literature, to figure out how to do that. I saw another hand. Please.
Could you give a comic book version on how litigation makes non-verifiable information verifiable?
That's going to be really hard. If you were to go back and take a look at this mechanism, it has 3 steps, and then the third step itself has 5 steps. And it goes something like this, but I'm not going to be able to give you the intuition very easily. The numerical example is about twice as difficult as the numerical example I did here. But the idea is basically, let's suppose that you were supposed to produce something for me of a fixed amount of quality, and then I was supposed to reimburse you for it, okay? For all your costs. And that was the thing. And then you didn't, and the problem is the quality was unverifiable, okay? And so I have an incentive to report low quality so that I don't have to pay you very much. You want me to report high quality, especially when it's high quality, so that I compensate you for the higher quality. To stop me from lying, we can go through the following process. Let's suppose I say it's low quality when it's in fact high quality. First, you challenge me, which sounds a lot like you file a suit. Okay? The second thing is that I have to deny it, which is a lot like I file an answer. And then the third step, which is complicated, is that you make an offer to me of a particular price, and then I have to decide whether or not to accept the good at that price. If I accept it at that price, we're done. If I don't accept it at that price, then we make another round of offers where instead I'm going to make a counter offer, okay? And then if we still don't resolve it, then we engage in some bargaining ex post, just like happens in a lot of these games. Now, if those offers are set right, just like the default provisions in the ADR contract that I was talking about, it's going to get me to want to accept the contract when your offer. And by doing so, show to the world that it's in fact a high quality good. If I don't do it, we're going to end up in some sort of bargaining situation that's going to leave me worse off. And that procedure has to, while I prefer within that procedure to tell the truth and not to tell the truth, the total amount of money that I have left over has to be less, at the end of the day, has to be less than what I would have gotten if I just told the truth up front, that when you gave me a high quality good, it was high quality. Now, I hope you kind of see that there are facets of litigation that are a lot like this. We have these counter offers. We have these counter things where you say, what is the valuation? If you disagree, file a suit. I can respond to the suit. Then we have these specific offers that we go back and forth with. Those are like settlement offers. And if those are done right, and we think that they can be done right, you'll induce me, the person that perhaps could be lying, to both within the litigation process to tell the truth and outside the litigation process to never want to lie and get into litigation. And what's really remarkable about this mechanism is that the court doesn't have to get anything right. It's totally unverifiable. So the court will never know, can never know, what the quality is of the good that you actually provided me. They could literally flip a coin and you would get the same result if the mechanism is structured properly. I think that's what makes this Moore-Rapullo mechanism so interesting and perhaps brilliant. The real question is whether or not it can be done in real life. And that's what we're gonna spend a little bit more time kind of it's like biologists looking for rare species. We're trying to see if we can find them in contract or in litigation. We think we can find it in litigation. Yes?
Another issue that we should take into account when we're thinking about this is antitrust relationship, because we're talking about integration and exclusive deals. Actually, it could also explain why some countries are more seems not to have problems with integration and others have more problems because of antitrust and the impact in the market of these kind of arrangements.
Yeah, so I would say two things about this. One is your comment reminds me to tell you, everybody here, that in fact legal scholars are in some sense way smarter than economists. Because as early as the 1930s and 1950s, lawyers realized that take-or-pay contracts, output contracts, and requirement contracts are substitutes for vertical integration. They didn't know why exactly. I mean, they thought it was just some control issue. They didn't realize the bigger holdup problem. The holdup problem hadn't come out yet. But they realized there were substitutes. They would see sometimes firms vertically integrating, and sometimes they'd see firms writing these contracts. They put that two and two together. And so they knew about the empirical relationship before knowing the theoretical reason for the empirical relationship. And the reason they worried about it is because they thought there were antitrust problems. They said, we're worried about vertical integration. Sometimes when we put antitrust pressure on vertical integration, firms instead use take-or-pay contracts or output contracts and things like that. But that's the exact same thing, so we should go after those as well. Okay? And so this early literature was all about how should we vary antitrust enforcement as between vertical integration and take-or-pay outputs, requirements, contracts. So in some sense, they saw the empirical relationship, but then they analyzed it through an antitrust prism rather than scope of the firm prism, okay, or ex-ante investment prism. So that's one thing. The second thing that's important about your comment is it shows that there could be other reasons beyond just the ex-ante holdup that could explain why it is that some countries have more vertical integration than other countries. It could be that in those countries they worry less about antitrust. Okay? That could be a reason. The only issue I have with that is that I would just then, I'd be like a 5-year-old and ask why. Why is it that some countries worry less about antitrust than other countries? Okay? Why shouldn't they all worry about antitrust to the same extent? Why don't they care about the consumers to the same extent? I don't have as much of a problem talking about why it is that some countries have more developed legal systems than other places do. There's just that, I think of that as a little bit more like a constraint. Can you construct a good legal system? Everybody's trying to, but some are going to be successful, some are going to be unsuccessful. And the ones that are more successful and able to enforce output contracts, take-or-pay contracts, requirements contracts, these sorts of things, they're more likely to see transactions on the market and less vertical integration. Countries that don't have court systems that are able to do that well are going to see a little bit more vertical integration. Yes?
It seems like, especially for these longer-term contracts, that whether or not the downstream buyer receives improved marginal benefit from improved marginal product is going to determine whether you actually see this. So if you have, say, Ford is buying certain part from a subsidiary, and all they need is from a supplier, and all they need is, you know, for the part to be able to hold 1,000 pounds, right? It doesn't matter if it can hold 1,000 pounds to them, 1,500. Whereas if they're buying oranges for orange juice, the extra sweetness of the orange does matter. And if the contract is only for, you know, we're going to pay you this amount for this amount of product, and it doesn't take into account the extra marginal improvement in the product, that there's going to be no incentive on the part of the original producer to make the marginally better product that's above conforming. So have you seen this? Have you seen that divide of where this comes up and where it doesn't come up?
So let me give you a two-part answer. The first part of the answer is, let's just translate what you just said into the numerical example here. You're saying instead of contracting on investment, what if you could contract on marginal costs? Then the buyer could say, I could say to Augustine, if you're able to lower marginal costs to 10, I don't care how you do it, that's fine. As long as you can do it, then we can write a contract. And that's in effect what you're saying. You can contract on the weight load on a particular component, or the degree of sweetness in the orange juice or something like that. If you can do that, that's like contracting on the investment. It's just another way to say that. And so I want to be clear that the examples that you're looking at are situations where you're in a complete contract world rather than an incomplete contract world. If you wanted to get into an incomplete contract world, imagine a situation like this. They had no metric for sweetness of orange juice, and you wanted the upstream producer of the oranges to invest in something that makes the orange juice or the oranges a little bit more sweet. That would be really, I mean, that would be more like the problem that I'm trying to address here. The one that you have that is, so that's the first part of the answer. The second part of the answer is, if you could contract on these components, then obviously things are going to be different whether or not there's a minimum amount that you need, and that's it, or whether there's a continuum. And then you can do it on both. What happens, however, if you can't contract on it? And sometimes you just need a minimum amount of weight bearing, and sometimes you need, there's a continuum. The sweeter the better. In that context, I gotta say I haven't thought completely about it, but here's my on-the-fly answer. My on-the-fly answer is you might be able to be a little bit better off if there's just a minimal amount, if there's some proxy for that somehow. Okay? Even some ex post proxy in a repeat relationship. Like the car fails because the component couldn't tolerate the weight, and then you could go back and put some of the warranty claims or the tort liability on the upstream supplier. Okay, you can share that. That would be one way to solve the problem. And there's a quick, if you met the minimum, then you won't see an accident. If you don't meet the minimum, you'll see an accident. Something like that. But if it's continuous, then it's much more complicated, because then you have to figure out, how much exactly, how much information can I get from ex post results that provide this finely graduated contract that says it's sweeter, the more I'm willing. Does that make sense? So I just think that discreteness makes it easier to write contracts, because you might find some alternative indicator. Continuation, it might be a little bit more difficult, but that's just an on-the-fly answer. Should we wrap up? Okay, thank you very much for taking it. In particular, thank you very much for the questions. I think that this is going to be very helpful for me when I think about the project moving forward.